And good afternoon, everyone. Welcome to today's ACLU Leadership Forum. I'm Cecillia Wong. I use she, her pronouns, and I direct the ACLU Center for Democracy, which encompasses our work on voting rights, immigrants' rights, national security, human rights, and speech, privacy, and technology. We've got a jam-packed program for you today, discussing some major civil rights and civil liberties cases on the ACLU's Joan and Irwin Jacobs Supreme Court docket, including major cases on voting rights, Indigenous justice, and affirmative action. We'll also give you an update on what's happening with our Reproductive Freedom Project's heroic work since the Supreme Court's devastating decision last term overturning Roe versus Wade. We've got 3 ACLU experts joining us today. Could I ask them all to turn on their cameras to say hello? Please help me welcome Brigitte Amiri, Deputy Director of the ACLU's Reproductive Freedom Project, David Cole, our National Legal Director, and Tedde Simon, Advocate for the Racial and Economic Justice Program at the ACLU of Northern California. Now, before diving in, let me first say that this is an off-the-record conversation. If we have any journalists among us, please understand that everything here today is not for attribution or citation. We're comfortable sharing our frank views about pending cases in front of the Supreme Court based on everyone's agreement that we're off the record here. Happy to follow up on the record if you like, just reach out. Now, we have purposely assembled all of you, this group of leadership supporters nationwide, first to thank you for your support, and also to give you an exclusive briefing designed to offer you some inside baseball, an inside look at our work. We'll reserve plenty of time for your questions at the end. You can use the Q&A function at the bottom of your Zoom screen to do that. And with that, I'll ask Brigitte and David to stay here, and Tedde will bring you back in a minute. So let's start with the Supreme Court and the general landscape. David, we'll start off with you. So for as long as I've been a lawyer, which has been almost 30 years now, the Supreme Court has had a conservative majority. But as we all know too well, the current court has a 6-3 majority that has proven hostile on many of our core ACLU issues. And last term was particularly devastating with the Dobbs decision on abortion. Can you give us a 3-minute overview? What are you seeing so far this term in the Supreme Court, and what are you forecasting through the end of the term to those blockbusters that tend to come in at the very end?
Thanks, Cecilia, and thanks to all of you who've joined us today for your support. So, you know, the court has, the 6-3 Trump-inflected court has now had 2 terms under its belt. The first term, it acted actually quite modestly. It sought to decide cases across party lines, deciding cases quite narrowly, reaching consensus. Last year, they threw out that playbook and went for the fences, overturning Dobbs, overturning a 100-year-old New York law that required people to show a need to carry a gun in public before they could carry guns around New York City or other parts of New York, etc. And this term, I think we'll get more data on where this court is going. Are they going to double down on that sort of using their political power to get their ends, regardless of what precedent says, or are they going to kind of try to cut back and respect precedent and seek consensus? They have a number of very, very troubling cases in which challengers have essentially invoked the Constitution to block other institutions from seeking to protect disadvantaged groups. That characterizes the challenge to affirmative action, the challenge to the Indian Child Welfare Act, which is one of the few federal laws that actually seeks to protect Native Americans by keeping their families together, challenged as unconstitutional race discrimination by the challengers. And Moore versus Harper, a case in which the Republican legislators who partisan gerrymandered maps in North Carolina are arguing that their own state court cannot invoke its own state constitution to declare what the state legislature did a violation of law. You know, how far they'll go, whether they'll accept these challenges, that obviously remains to be seen. I do think it's important to keep in mind, though, that over time, the court, no matter what its political inflection, over time, the court has rarely parted company very far from where the sort of core of the country is on fundamental values. And when it does, there's a pushback, and the court often then corrects itself. I think they went overboard last term, and I think the question is, when will the correction come? And that really turns, I think, on us, on the Americans speaking out, attacking what they have done, working with civil society organizations to fight back against what they've done. That's the way we respond to court decisions that we don't like, and so that will determine in the long run where this court ends up.
So, Brigitte, that's a great segue to you. I know that you and our colleagues in the Reproductive Freedom Project are hard at work trying to get that correction started. Tell us what's new and what have you been doing to try to claw back our abortion rights after Dobbs?
Yeah, so the ACLU was really made for this moment. We are doing everything that we can to protect access to abortion, restore access to abortion wherever we can, working across departments with all of our affiliates and all of our partners to really mitigate the horrible devastation that the Dobbs decision has caused. And I really cannot understate overstate how horrible this decision has been for people's lives, and particularly for people who are the most marginalized in this country. So immediately after Dobbs was decided, more than a dozen states banned abortion, and we rushed into state court under state constitutions in many of those states. And we had trials over the last few months in places like Kentucky and Ohio and Georgia. And honestly, we've had some mixed success. We've been able to protect abortion in some places, and we've not been able to in others. And we are still fighting. We have about a half a dozen of those cases still pending, and we are hopeful for good results in those places. And our federal litigation continues apace. We haven't given up on the federal courts. There are some federal constitutional claims that the Dobbs decision did not disturb. And in fact, we just filed a new federal case challenging restrictions on abortion in West Virginia. And we have a federal appellate court argument in one of our cases in Guam. So the fights continue in the court, and in the meantime, our colleagues in the advocacy and policy departments in the national office and the affiliates have been on overdrive. And I was so heartened to see the success that we had at the ballot in 2020. All of the abortion measures on the ballot were successful, were in favor of abortion rights. And that speaks volumes in terms of what people want in this country. They do not want to see abortion banned and restricted. And that work has happened in coalition, grassroots efforts, and wonderful victories in states like my home state in Michigan and in Kentucky, where I've spent so much time litigating. Also, we are getting ready to prepare for the worst. We are preparing if these criminal bans on abortion are enforced, what happens to people? And so we are soon going to launch an abortional criminal defense initiative to ensure that people, healthcare providers who are criminalized, have the representation they need.
Thanks, Brigitte. I think it's interesting that both you and David are talking about the ways in which our litigation in the Supreme Court and in other courts really is just one piece of a larger strategy that we have across all of our issues, particularly in those issues where we're faced with a crisis situation. And we've got to look to other tools besides litigation to get to where we're trying to go in our country. So let's keep that in mind as we turn to a deeper dive on some of our Supreme Court cases. And Brigitte will bring you back in a few minutes. So David, let's turn to voting rights. There are two critical racial gerrymandering cases, redistricting cases, that could potentially really drastically upend our electoral process in the United States. We've got Merrill versus Milligan, a case where the ACLU is representing the party, challenging racial gerrymandering with Alabama's state constitutional districts. And we've got Moore versus Harper, a case where we filed an amicus brief, and that case brings up this so-called independent state legislatures doctrine. Can you walk us through what's up in these two cases, what's at stake, and tell us if you have any predictions about what the court's going to do based on what we've seen so far?
So sure. In Merrill, the statute that's at issue is the Voting Rights Act. It's one of the most important civil rights statutes that the Congress has ever enacted, and it is really the reason that African Americans and other members of minority groups have an opportunity to elect representatives of their choice in some places. And it essentially requires that if you've got a state where there is a history of racially polarized voting, and you can demonstrate that it's possible to create X number of districts in which members of a minority group that have been discriminated against have an opportunity to elect representatives of their choice, the statute requires that the state do that. And we demonstrated that in Alabama, applying well-established law. We did it without any real, controversy that in Alabama, Black Americans are 28% of the population. They have only one of 7 districts. That's about 14% of the congressional delegation. They could easily have 2, which would give them roughly proportional representation. Our showing was so strong that the 3-judge court was unanimous. It included a Trump judge who ruled in our favor. But the court has taken it up, and essentially Alabama is arguing that this Voting Rights Act violates the Equal Protection Clause by requiring plaintiffs to consider race in answering that initial question of whether you could create an additional majority-minority district. If the court were to accept that position from Alabama, it would essentially neutralize that act, and it would no longer be an effective tool. In Moore versus Harper, as I indicated before, the Republican-dominated legislature in North Carolina created a radically partisan gerrymandered map. That was challenged in state court under the state constitution, and the state court held that it violated the state constitution. The legislatures then went to the U.S. Supreme Court and said that the Constitution bars a state court from enforcing its own constitution against its own legislature, that the legislature is essentially above the law when it comes to drawing maps and can't be constrained even by its own state court and its own state constitution, which after all is the basis for the authority of the legislature in the first place. A couple of years ago, the Supreme Court said that there's no federal remedy for partisan gerrymandering. It's too hard to draw the lines. But in that decision, Chief Justice Roberts said, yeah, but you can go to state court. There are remedies in state court for partisan gerrymandering. Well, if they accept the challenger's rule here, the challenger's argument here, there'll be no remedy in state court for partisan gerrymandering either. As to how the court will come out, I suspect that it will not accept the sort of most extreme arguments that the challengers have made in those 2 cases. They're very extreme, but the devil's in the details in terms of where they end up short of those extreme results. We're fully expecting that we will continue to be litigating Voting Rights Act challenges. We have a whole bunch that are essentially on hold pending the decision in the Merrill case, and we're ready to go as soon as that decision comes down. But I think there's no question that the court's going to make it harder for us to prevail. The question is how hard.
Thanks, David. And I think I may have misspoken and said that Milligan is about Alabama's state legislative maps. It was like a congressional seats, like House of Representatives, of course. So in light of the state of the Supreme Court today, we are looking to other venues to bring our litigation, and that means the state courts. As Brigitte said, in the reproductive justice context, we are looking to state courts while we're still filing cases in federal courts. We're doing the same in voting rights. For example, we brought and won challenges to Ohio's gerrymandered congressional and state legislative district maps in state court. And we won both of those cases in the Ohio Supreme Court. And of course, during last year's congressional and midterm elections, we brought election protection cases in local and state courts in several places in the country. Let's change subjects and move on to our next case, Brackeen versus Holland. At the center of this case is the Indian Child Welfare Act, which David mentioned at the top of the hour, in which the National ACLU and 12 of our affiliates are urging the Supreme Court to uphold Congress's law in the ICWA. So Tedde Simon, let's bring you on. You're one of our key ACLU advocates on Indigenous justice issues nationwide. And David, we will see you shortly. So Tedde, along with being an advocate for the Racial and Economic Justice Program at the ACLU of Northern California, you're also a member of the ACLU's relatively new Indigenous Justice Working Group, which has been really active in the Brackeen case. Can you share a little bit of background with our leadership supporters about how ICWA protects Indigenous children and Indigenous families around the US?
Thank you. Good afternoon, everyone. To really understand the importance of ICWA and what's at stake in this case, we have to go back to the beginning. Since the time of contact, the US government, seeking to settle and colonize this land, attempted to eradicate tribes and destroy Indigenous people's futures. And one of the main tools they used was the forced assimilation of Indigenous children. And it goes something like this: if all Native children are severed from their tribes, scrubbed of their Indigenous identity, prevented from passing language, culture, tradition on to the next generation, indigeneity ceases to exist. So starting in the early 1800s, Indigenous children as young as 4 were often violently torn by their families, from their families by federal agents, and shipped to militarized institutions. These federal Indian boarding schools were never intended to be educational. They were intended to kill the Indian and save the man. Upon arrival, little kids were immediately given new Anglo names, their clothes were taken, their hair was shorn. Draconian rules prohibiting the speaking of Native language or practice of any culture or ceremony were enforced through brutal corporal punishment. And as you can imagine, abuse was rampant. With the end of the federal Indian boarding school era came the Indian Adoption Project. Created in 1958, the goal of this project was to promote and facilitate the adoption of Native children by white families. By the end of this era, around 80% of Native American families living on reservations had lost at least one child to the foster care system. It's a devastating number. This was a crisis, and the very survival of Native nations and Indigenous cultures was at stake. So Indigenous leaders pushed Congress to act. A 1977 congressional report found that 25 to 35% of all American and Indian and Alaska Native children had been removed from their homes, and something like 90% of those children were being raised in non-Indigenous families. And that report became the basis for the Indian Child Welfare Act. Congress passed ICWA to protect the best interests of Indian children and to promote the stability and security of Indian tribes and families. Importantly, ICWA applies only to children who are members of federally recognized tribes or are eligible for tribal membership. Recognizing the history of discrimination and stereotypes that led to vastly disproportionate removal of Native children from their homes, ICWA requires active efforts be made before a child is removed from their birth family. ICWA creates and strengthens mechanisms for tribes to be involved in child custody cases of their citizens, and creates a series of placement preferences for children once removed from their homes, prioritizing first placement with kin then within a child's tribe, and then another Indigenous tribe before placement with a non-Indigenous family. ICWA implementation is far from perfect, but it's still an incredibly important law to safeguard the individual rights of Indigenous children and families and protect the collective rights of tribal nations as sovereigns.
So it's really striking to me, Tedde, that ICWA, along with other really fundamental human rights and civil rights laws that Congress passed in the 60s and 70s, along with Section 5 of the Voting Rights Act, are under attack now. So can you tell us, what's the background of this case getting to the Supreme Court? How did this come about?
Yeah, this case really is terrifying. An adverse ruling in Brackeen would have devastating impacts on Native children and families, but also throw open the doors to a vast array of challenges to tribal sovereignty, self-determination, and the existence of Native nations. So just a quick note on tribal sovereignty, because it's so central to this case and to our work. Tribal sovereignty is the right of Native nations who existed long before the creation of the United States to govern themselves. This sovereignty, affirmed through treaties and other laws, is inherent. It's the right of tribes to protect and celebrate our unique ways of knowing and being, to make decisions about our children's welfare, and to live by our own systems of laws. And defending and advancing that tribal sovereignty is central to our Indigenous justice work here at the ACLU. So back to the case. The Brackeens are a white, evangelical, upper middle class family in Texas. They filed suit in federal court in 2017 challenging ICWA while fighting custody of a child in family court against the Navajo Nation and a child's relative who wanted to adopt him. And even though they eventually prevailed in family court and were able to adopt the boy, they still nonetheless claim that ICWA is unconstitutional because it impermissibly discriminates on the basis of race, exceeds Congress's power over Indian affairs, and impermissibly commandeers state judges. And really the scariest argument that plaintiffs are advancing is that ICWA violates equal protection in that it discriminates against them as a non-Native family looking to adopt Native children. Reducing Indigenous identity to a racial category jeopardizes the very concept of sovereignty that I just spoke about, and jeopardizes the right of Native nations to exist as sovereigns. To be really clear, ICWA is not about race. It applies to children who are members of or eligible for membership in a federally recognized tribe that is a political status, not a racial classification. So the Brackeens fought the Navajo Nation and the child's relatives because they believed that they could offer him a better life. That's not dissimilar from past governmental policies, wholesale removal of Indigenous children from unfit parents. So this case is about reproductive freedom, not only our right to choose not to have children, but our right to have children and our ability to raise the children we choose to have with dignity. There's overwhelming evidence that being removed from homes and disconnected from culture and tradition is deeply harmful to Native children, and overwhelming evidence that Native children do better when they're connected to kin and land and culture. So finally, ICWA protects the future existence of Native nations and is in the best interest of individual children and families. But Native nations continue to be in the way of the settler colonial project. And I think something that's particularly dark about this case is that it was originally filed by the Gibson Dunn law firm, who has long fought tribal nations on behalf of big oil and other moneyed interests. Folks will remember images of water cannons pointed at water protectors at Standing Rock in sub-zero temperatures. Gibson Dunn represents Energy Transfer, which is the pipeline behind which is the company behind the Dakota Access Pipeline. So this case has very little to do with advancing best interests of Indigenous children, but about undermining sovereignty. And I'm so proud that we at the ACLU are able to stand beside the hundreds of tribal nations and human rights and civil organizations in defending this law.
And I think it's also historically resonant and moving in interesting ways that this case is titled Brackeen versus Holland. And the Holland, of course, is Deb Holland, our first Indigenous American member of the cabinet, and herself a member of the Laguna Pueblo. Tedde, you and other Indigenous colleagues at the ACLU have been really in the lead on not only the Brackeen case, but in developing our racial justice work in the area of Indigenous justice. Is there something that our leadership supporters can do and non-Indigenous colleagues at the ACLU can do to help on the Brackeen case and in the cause of Indigenous justice more generally?
Yeah, thank you. And I think this applies to Secretary Holland as well. There's not an Indigenous person in this country who isn't impacted by all of the issues that we've spoken about today. Many people are direct descendants of survivors of boarding schools or forced adoption, and all of our communities are struggling to overcome intergenerational trauma and the lasting legacies of settler colonization. And we can't do Indigenous justice work if people don't know about the issues. We can't do Indigenous justice work if people don't even know that Indigenous people are still here and that tribal nations exist. And so your help in combating that invisibility and erasure are critical. We want to ask you today to listen to an At Liberty podcast called Is SCOTUS Coming for Indigenous Children, and share it with at least 3 friends or colleagues. The podcast features the incredible and moving story of Jamie Nelson, a friend of mine and a survivor of forced removal, who's on his own journey to heal and stop what happened from him from happening to other Indigenous families. And in sharing that story, really raising awareness and preparing people to join the fight that is yet to come. Thank you.
Thank you, Tedde, for your leadership and for sharing with our leadership supporters today. We're going to transition to another policy that has been meant to eradicate and reckon with our nation's history of racial injustice, and that's affirmative action. Those intent on maintaining a status quo continue trying to dismantle many of these laws and protections, ICWA, the Voting Rights Act, as I mentioned before, and let's turn to affirmative action. So, David, we are supporting the University of North Carolina and Harvard in cases where they're trying to defend their ability to consider a student's race as one among other factors that make a person who they are when it comes to deciding whether to admit a student. Talk us through what is at stake in the UNC and Harvard cases.
So what's at stake is the future of affirmative action, and it doesn't look good. The challengers argue that the Constitution requires color blindness. I mean, that's essentially the argument they're making in the Voting Rights Act case we talked about a moment ago. It's the argument that they're making in challenging the Indian Child Welfare Act, and it's the argument they're making in challenging affirmative action. At both private institutions that receive federal funds, which is basically all private institutions, and state institutions. And the argument suggested that affirmative action is going, and the only question is when. It's possible that they will say that it should go in 2028, because in 2023, the Supreme Court issued an opinion upholding affirmative action, but in that opinion written by Justice O'Connor, she said, "We hope that this will only be necessary for another 25 years and that it will end at that point." And so it's possible that they say it ends in 2028. It's also possible that they say it ends in 2023. It's very unlikely that they uphold affirmative action at this point.
Which will really spell a disaster, I think, for our country. You know, as an alumna of the University of California, class of 1992 at UC Berkeley, you know, I really benefited from affirmative action and having a diverse student body. I learned so much from being part of that student body. And when the state of California eliminated affirmative action with Proposition 209 back in 1996, we saw both Black and Latino student enrollment plummet in ways that I think have had long-lasting adverse effects on the University of California. Let's transition again to another subject. Thank you, David. Let's bring Brigitte back on and talk about the mifepristone case. This is an issue, medication abortion, which is not before the Supreme Court, not yet, but it's certainly on our watch list. There's a case that's now sitting in a Texas district court, and it revolves around the Food and Drug Administration's decades-long approval of mifepristone, a pill you can take, that's medication abortion. It has been safe. It's been effectively used by millions of people for over 20 years for early abortion care, and more recently for miscarriage care. Can you talk us through this medication abortion case and what the potential implications are?
Yeah, the case is so frightening that my office lights turned out as soon as you started talking about it. It's frightening. And, this is the type of case that is riddled with procedural errors and would normally be laughed out of court if it were in front of almost any other judge. But the anti-abortion group that filed this case handpicked this judge to file their case in front of, knowing that he was extremely hostile to reproductive freedom. So what this case could do, and we may get a decision within the next, even as early as next week, is it could force the removal of one of the two drugs in the medication abortion regimen to be taken off the shelves. And we don't know if that would happen, but it is very terrifying, the prospect of that, and the devastation that would be compounded on abortion access. Already we have seen the tremendous, horrible effects that Dobbs has had, and then to decimate abortion access for medication abortion would just be even more devastating. But I think also this case is important because it gives an insight to the other side's strategy. We know that the other side wants to ban abortion nationwide. And so I like to say that even if you're in New York or California or a place where you think based on your state abortion is safe, you have another thing coming, because the other side has been working very hard to try to ban abortion nationwide. And they won't be content with that. They're coming after contraception. The same judge that is deciding this medication abortion case just recently issued a decision that said that minors must have their parents' consent in order to obtain contraception. Obviously, all of these issues that we're talking about are interrelated. Tedde talked about the connection with ICWA case to reproductive freedom, and so many of our issues at the ACLU are interconnected. And I also think very pointedly about the connections to the fights that our colleagues down the hall are having with respect to protecting access to trans-affirming care. These are cases about bodily autonomy, reproductive freedom, and they're all connected. I fear that things are going to get worse before they get better, but working together, including in partnership with all of you, we have to make sure that we can mitigate as much harm as possible, prevent things from getting even worse, while simultaneously working towards a time when everyone can have true reproductive freedom and autonomy.
Thank you, Brigitte. We're about to switch into questions and answers. We'll be answering your questions. So let me bring back both Tedde and David, and Brigitte, stay with me. While we're teeing up questions, David, let's talk about a case that people might be interested in. What is at issue in Gonzalez versus Google, and a similar parallel case in Twitter versus Tamne?
So thanks. So these are cases where we actually are, I think the court might well do the right thing, but they are two cases suing social media platforms, Google, YouTube, Twitter, on behalf of relatives of terrorist victims, of ISIS terrorist victims. And the claims are that these social media platforms are liable for the acts of terrorism because on their platforms at one time or another were messages or videos by people connected to ISIS that would-be terrorists might watch, and it might radicalize them and cause them to support ISIS and allow ISIS to engage in terrorist violence. I mean, the terrorist violence is obviously completely horrific, but the notion that social media platforms should be liable because a post was put up is a pretty far cry. And one of the questions in the case is whether something called Section 230, a statute that Congress enacted in 1997, bars these kinds of claims. And essentially what Section 230 did was it said, we want the internet to be free and accessible to everybody. And if internet platforms could be held liable for the content that people put up on the internet, then they have to review everything that anyone wants to put up before they put it up, and the internet would die. And so Congress enacted a statute that says the platforms cannot be sued for publishing the content of others when that content is the problem. Those others can be sued, but the platforms can't. But here, the relatives of the victims are seeking to essentially pierce that veil and hold social media platforms liable for third-party content. And if they were to succeed, it would be the end of the internet. Now, some people might think that's a good thing, but we don't. We think that the internet has a lot of problems, no question, but it is an incredibly important resource for free speech and for people without means to be able to express themselves, to collectively organize, to assemble and the like. And that would be all over if YouTube had to review every video that anybody posted, and Twitter had to review any tweet that anyone posted and have their lawyers vet it and make sure it's not be the basis for a lawsuit before it goes up. So we're supporting Google and Twitter in these cases. We challenge Google and Twitter in other contexts. We try to maintain the free, open internet, but here the law that they are relying on is critical to that open internet.
Thank you, David. We'll be watching carefully in our corner of the ACLU legal department. So Makiba, shall I go to the first batch of questions?
Yes, we've actually had a high amount of questions come in advance of the call. So there are a few here that I have for you that we're going to lift up. We're going to start with first.
Great.
The first one is from Marinita L. Their question is, has the Indian Child Welfare Act been applied to Hawaiian, Alaskan, and Indigenous persons? Another question came in, what is the ACLU's stance on court packing, and what other options do we have to make the court fairer and more reflective of the will of the people? And then the final question in this first batch is from Alan M. Do you expect that your abortion protecting victories in state courts will withstand legislative pushback in those states?
Great. So Tedde, let's start off with you. Can you answer Marianita L's question? Does ICWA apply to Hawaiian natives and Alaska natives?
Yeah, this is a great question. So first, for the ACLU, in all of our Indigenous justice work, Indigenous is an inclusive term. It includes all of those people who were living together as a community before contact with settler populations, which means that there are Indigenous people from every inhabited continent on Earth. ICWA, though, is limited in its protections to American Indian and Alaska Native people, those who are enrolled in or eligible for enrollment in a federally recognized tribe or Alaska Native village. What that means in terms of this great question is that ICWA does not apply to Native Hawaiian people or to members of tribes without federal recognition. There are 574 tribes and Alaska Native villages that are federally recognized, and nearly 400 tribes across the US without federal recognition, either because Congress refused to ratify treaties, or tribes were terminated, or never recognized. And that lack of federal recognition really has devastating impacts on tribal nations because they don't receive the protections of federal laws like ICWA. They don't have jurisdiction over tribal lands, and they have so many more challenges in providing for their citizens and defending their collective rights. So it's a really important question both in terms of who ICWA protects and does not, but also in terms of pointing to a much larger civil liberties issue that many Indigenous people face.
Thank you, Tedde. David, I'll throw you the question about court packing and other Supreme Court reform proposals. What's your view? What can the ACLU do, and how should we engage on these questions?
So thanks. I think court packing is mistaken in principle and also not really pragmatic. It's mistaken in principle because I think it would simply further politicize a court. And the whole idea of having a constitution and a court that protects constitutional rights is so you have an institution that is not responsive directly to the political will of the majority, because it's there to protect rights that we want to protect from the majority: the right of free speech, rights of equal protection, rights of minorities, rights to vote, etc. So if you support court packing, the real risk is, the Democrats put 4 new justices on when they can, and then the Republicans put 2 new justices on when they can, and it goes tit for tat until you've got a massive court in which everyone's voting their party line. Then there's really no difference between the court and Congress. It's also, I think, not pragmatic because there's nowhere near the votes to do it. It's never been a successful strategy. FDR, probably one of this country's most popular presidents ever, tried it at a time when the Supreme Court was at its lowest ebb in terms of popularity, when it was striking down laws protecting consumers and workers during the Depression, and even he couldn't get it enacted. There are other court reform that we support. The 18-year term, staggered term idea, which would give every president 2 appointments to the court. We think that would decrease the politicization of the court. And if it's constitutional, a big question that the Supreme Court would have to decide, that might well be an improvement on the situation. But I think that's also not politically likely in the near term. And so I think the way you fight back against a court that is doing the wrong thing is by fighting on the issues that we care about. Fighting for abortion rights, fighting for Indigenous people's rights, fighting for racial justice, fighting for free speech rights and transgender rights. And if we had the political will to enact some of the kinds of court reforms that people have talked about, we could pass a law that protected abortion for all. We could pass a law that amended the Voting Rights Act to correct all the problems. We could improve on the Indian Child Welfare Act. So I think the place to focus our attention is on the substantive issues, the core values that we care about, rather than the composition of the court.
Hear, hear. Brigitte, let's answer Alan M's question. We've all heard press reports about abortion opponents now going to state legislatures to try to undo our state court litigation victories. What's going on there?
Yeah, so I think the answer goes back to all tools in the toolbox are needed. So even if we can restore or protect access to abortion under state constitutions and state courts, when state legislation is being considered that would affect that, would push further restrictions, we will certainly go to court where we can and try to seek to strike down those laws, and we hope that they would do so. But people need to have their legislative representatives on speed dial and need to tell them exactly where they stand on this issue. Even if you think that your legislator supports abortion rights, it's really important for people to hear that it's a priority issue. So we need to engage with our elected officials, tell them we don't want these laws in the first place. And where we can, if they do get passed, we will challenge them in court.
Thank you. All right, Makiba, I think you have some live questions for us. Makiba, any questions for us? Okay, I'm going to go to some of the questions that were submitted in advance. I like this one. Roseanne P asks, what can an 80-year-old supporter who is not able to march do to support abortion rights? You've already said one thing, which is get on the phone to your state legislator. Are there other things that people can do?
Yeah, I think, getting on the phone with your elected officials at every level of government, local, state, federal, having them on speed dial, calling them, telling them that this is an important issue to you is incredibly important. Voting, obviously, your values, every chance you get. Talking to people about abortion. A lot of the restrictions and bans we have seen are enforced by stigma and shame about abortion. And the more people talk about abortion and abortion as healthcare, it reduces the shame and stigma. And contributing to organizations that support abortion rights, reproductive justice organization, abortion funds, civil rights organizations, finding out in your local community how to tap into that infrastructure and be supportive. There are lots of ways to do that.
Great. Okay, we've got a question from Gordon W. about partisan gerrymandering and ACLU work on partisan gerrymandering. So I'll start with this one and see if David has any additional thoughts. As David said, a few terms ago, the Supreme Court held that partisan gerrymandering is not justiciable in federal courts. In other words, federal courts don't have any basis on which they can answer questions about partisan gerrymandering. But Chief Justice John Roberts left it open, in that opinion, for people to go to state courts. Well, lo and behold, people have done that, and we have this challenge in Moore versus Harper through this so-called independent state legislatures doctrine. I think that case is obviously has the potential to really foreclose partisan gerrymandering claims. But there's room for, there's play in the joints there. So for example, our Ohio case in which we challenge partisan gerrymandering, the state constitution in Ohio was actually amended to provide for the state courts to have a role in looking at redistricting. And so we have made the argument that the Ohio case, however the court decides the North Carolina case in Moore versus Harper, is one in which the Supreme Court would have to not only override what the state Supreme Court did, but would have to override what the state constitution provides in terms of the respective roles of the state legislature and state courts. Aside from litigation, we're really looking to all the political tools that Brigitte has discussed in the abortion context, going after ballot initiatives, engaging with state legislatures, engaging in states that have independent redistricting commissions to come up with maps that are not gerrymandering, either on the basis of race or on the basis of political party. David, what thoughts do you have about the future of our work on partisan gerrymandering?
No, I think you've covered it, and I do think independent commissions are, in some ways, one of the best responses, because you take this job away from the legislature, which obviously has a kind of self-interest in preserving its positions, regardless of whether the people change their mind. So that's I think the single best response. But I don't think Moore versus Harper is going to preclude all constitutional challenges to partisan gerrymandering in state courts, and we will continue to fight it. It is a pernicious practice. It has the legislatures picking the people who elect them rather than the people picking the legislators who represent them. It's wrong, and we will continue to fight it in every way we can.
Amen. John K. has a question. How pronounced is the conservative tilt below the Supreme Court level in the courts of appeals and the district courts?
So that's a great question. And I think there's a number of ways to look at it. One is that Trump appointed more judges in his 4 years than any other president in 4 years. And when he left office, 25% of the federal judiciary were Trump judges. So that's concerning, but that means 75% of them are not. 40% of them at that point were appointed by President Obama. And President Biden has basically matched Trump in his first 2 years. So we can still get a fair shot for civil liberties and civil rights in many federal courts across this country. In addition, just because a judge is appointed by Trump doesn't mean that they're necessarily hostile to civil rights or civil liberties. We've won some important victories with Trump judges voting on our side, including the Merrill, Alabama voting case that we talked about earlier, but also our recent victory striking down the use of Title 42, a purported COVID restriction to deny people entry at the border, even if they have fully legitimate asylum claims. We won that in a district court. It was affirmed by a Court of Appeals panel, including a Trump judge who basically invited a broader challenge to the law. So not all the Trump judges are lost causes with respect to civil rights and civil liberties. We continue to win cases, consistently in the federal courts. So, litigation remains important. The other thing I would say is, people focus on the Supreme Court, 6-3, 6 very conservative justices, but most cases don't go to the Supreme Court. On any given day, the ACLU, the larger family, the ACLU has about 1,500 to 2,000 cases pending. Every year, about 3, 4, or 5 of them go to the Supreme Court. The vast majority never get to the Supreme Court, and we win many of those cases, settle them, the court doesn't review them, etc. So, I think the important message here is courts are still a critical part of the toolbox. They're not the only part, and we have to look for other forums, and particularly, I think, state courts using state constitutional arguments, as Brigitte and the Reproductive Freedom Project have done. But we're not giving up on courts.
Absolutely not. And as Brigitte said, in abortion, we're not giving up on federal courts. And the same is true of so many other issue areas. The one example that is close to my heart is, the one Supreme Court argument I had a couple terms ago was in an immigration detention case where we were trying to limit the use of mandatory detention without a hearing of people who were fighting their deportation cases. We lost that case in the Supreme Court, and it was a devastating loss. But I reminded all our colleagues and our coalition partners that we got thousands of people a hearing in front of an immigration judge at earlier stages of the case. And the majority of those people were released once they got a hearing, and they otherwise would have been locked up in an immigration detention center. And each one of those thousands of people went home to their family, went home to their job, and were in a better position to fight the government's deportation charges against them. So the work we continue to do, both in federal and state courts and in the legislatures, is so important and has such a huge impact, regardless of conditions at the Supreme Court. So I think it's important to broaden the lens, even in a program about our Supreme Court docket. Let's see, we can take, I think, actually, we've got one more question. I'll throw this open to any of my 3 colleagues. Maiden G asks, how can we go on a legal offensive? How are we going to play offense?
So I can start just by saying, don't underestimate the importance of playing defense. Civil rights and civil liberties are about protecting us from government overreach. That's to some extent inherently a defensive function. It's when the government intrudes upon our rights that we stand up, fight back, sue, and seek to challenge what they're doing. Rights are, just words on a piece of paper, unless you have organizations that are around, ready, and able to defend those rights when they're under attack. But we're also going on offensive. The fight for LGBT equality has been a story of advancing protection through the entirety of my legal career. When I started, it was perfectly permissible to make it a crime for two people to have a sexual relationship if they were of the same sex. Today, it's constitutionally forbidden to do that. It's constitutionally protected to marry, and we've succeeded in expanding protection from employment discrimination to both discrimination on the basis of sexual orientation and on the basis of gender identity in a case called Bostock that we did a couple of years ago, in which we Justice Gorsuch wrote the opinion. So we're pushing forward, and we can continue to push forward. But I want to emphasize defense is absolutely critical, right? What Brigitte is doing is defense, 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 and it has been absolutely critical for 50 years.
Thank you, David.
No, Brigitte hasn't done it for 50 years. I'll say that.
Oh, thanks, David. Thanks for that clarification. I appreciate that.
I think that's a great note to end on. I want to thank you, Tedde Simon. Thank you, Brigitte Amiri. Thank you, David Cole. Thank you to our ASL interpreter. And most of all, thank you to all of you listening and participating with us today. Thank you for your support. And please take good care of yourselves as we go forward fighting for freedom.